Dirty. All persons having anything to do before the honorable, the justices of the appeals court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Just before I call the first list, let me say good morning to everyone and introduce the panel to you. To my right is Justice Vicki Henry. To my left is Justice Chauncey Wood. My name is Ariane Vuono. I see two veteran, or I'll say this, two experienced attorneys in front of me, so you both know that you have 15 minutes to present your argument. I'm sure you also both know that there is no rebuttal. Those two comments will go to everybody else who's sitting in the courtroom right now who is going to be arguing later on today. We only have 5 cases on the list today, so we're going to be taking a short break after case number 3. First case is 2024-1016, Michael Marks versus DEVRY Education Group, Inc., and another. Attorney Hand, good morning.
Good morning. May it please the Court, Dana Curhan representing Michael Marks. First issue I'd like to address is the statute of limitation. The judge in this case found that the Auburn University sent Marks a letter in February of 2017 saying you're out of the clinical program, and the judge treated that as the triggering event. The problem is that he was actually enrolled in Ross, and Marks went through an administrative process at Ross that started after he got the letter but didn't end until the middle of 2021, and he filed his complaint in 2022.
Right, but at Record Appendix 79, your opponent points out, quote, however, Dr. Givens from Ross stated that if I did not finish at Auburn, I would not finish at all, close quote. So your opponent makes the point that that is a clear and unambiguous message from Ross in 2017 that that Auburn is the definitive point here.
I think we have to look at the bigger picture. That was an event certainly, but there was an administrative process. The fact that somebody says, well, if you don't finish there, you're out of here. There was an administrative process that was followed, and there are 22 programs that Ross refers its students to. And the hope and expectation of Marks was that one of those other programs would make accommodations, and Ross would simply assign him to that other program, to a different program. And that didn't become final until 2021.
So they cite, Ross cites a bunch of cases, or a couple of cases on page 28 of the red brief that basically says that there's filing of a grievance does not toll the statute of limitations. What do you say to that?
Well, I mean, there are a couple of cases that I cite that say that a grievance procedure does, in fact, toll the statute of limitations.
But he says those are collective bargaining cases, and so they don't apply here.
And they are CBA cases, aren't they?
They are. I think one's an MCAD case, but I think for present purposes, there was a process that was available. I think if Marks had filed a grievance, or I'm sorry, if he had filed a complaint. And then filed a grievance, probably that complaint would have to be stayed pending the grievance process. I mean, and he was unrepresented, so he didn't necessarily follow the advice of counsel. But that said, there was a legitimate grievance process, and there is. I don't read any of my brother's cases as saying it just doesn't apply. I think maybe it's a case of first impression, but I'm not sure. I don't think so. So I think, certainly as to Auburn, when they said, you're out of our program, that's when the statute started running as to them. But Ross, I think there was still an opportunity to save things. even after the Auburn letter. Regarding whether, I think my brother argues that that this issue is being raised for the first time on appeal. What I would point to is pages 72 and 73 of the record appendix, which is the opposition filed to the motion to dismiss, and also pages 181 to 183 of the record appendix. And I think counsel said something like the claims, in particular the 93A claim, is timely. That doesn't waive any of the other claims. I think that's clearly something that was brought up, and the judge treated this argument as having been made. So I don't think this is being raised for the first time on appeal.
Sorry, can you, I see a distinction between the misrepresentation claim and the 93A claim. And your opponent, I think, is saying that you raised the 93A claim or the statute of limitations argument on the 93A claim below, but not the statute of limitations argument on the misrepresentation claim. If I've got that right, if I've got that wrong, correct me. If I've got that right, where in that, did those RA sites make clear that below you had raised the misrepresentation claim as opposed to the 93A claim?
I think on those pages I cited.
72 and 73 or 181 to 183?
Right.
Okay, I'll go back and check that.
So clearly, Plaintiff Marx's claims were continuing through the grievance process and up to including the decision in 2021, and his 93A claims extend. I mean,
You're quoting from page 14 of the judge's decision, right?
No, I'm quoting from page 73, which is the opposition.
Gotcha.
I mean, there is a reference to all the claims. It is, I think counsel probably really wanted to save the 93A claim. That's what gives him a lot of the leverage, but he still, I think, referenced all claims and made that argument. And the judge treated it as all claims.
Okay.
So that's my contention. And I think there are two ways of looking at this. The first is that the triggering event was in 2021, and the second is that, that's not, the cases that my brother cites, that doesn't necessarily address that argument. That I think is, the fact that somebody told you that you weren't going to be able to finish, that's one thing, but a final decision from the Education Committee that you are out, I think that's the triggering event. And the second way of looking at it is that there is some sort of equitable tolling during the grievance process. The second issue raised by this...
Just looking at this Kaufman case, which is ours from 1984, and I will say, it was a long time ago, and decisions might be brief then. Why is it wrong? I mean, because it does basically say, it is a school committee case, so presumably there was actually a collective bargaining agreement, so I'm not sure how that reconciles with your cases, but it does seem to say that even if the school officials knew he intended to file an appeal, that notice alone is insufficient to toll the statute of limitations.
Well, I mean, this was an entire grievance process that the university has. And I think that was...
I'm sympathetic to what you're saying because it does not seem like the best use of court resources to proceed forward. And I could see exactly what you're saying is that, which is a judge might hold the case while the grievance process played out.
Well, I mean, and unfortunately that wasn't done here. He was working on his own, but I still think, I think we're in a situation where he took the remedies available to him, and he didn't get a final decision that he was out until 2021. And that, I think, is the triggering event. It's not, conversations he had earlier or the conversation or the letter from Auburn, because Auburn was just one of the many schools that, and by the way, it wasn't Marks who chose Auburn. It was Ross. It was the school that chose Auburn.
Yeah, so one thing I was confused about and would ask both parties is, when he's at Auburn, is he simultaneously at Ross? He's still a student of Ross, is that the idea?
I think that's the idea, because Ross doesn't have a clinical program, and what they explained to him at the beginning is that we send you to a clinical program for the 4th year. And he was successful in all of his rotations, with the exception of the emergency rotation, because he couldn't prepare his discharge
summaries.
reports in a timely manner. And that's something that probably could have been accommodated.
Did I understand you to also argue that the whether or not the triggering event was when your client was first notified of the fact that he was not going to be able to finish, or whether or not when the process played out, that was a triggering event, that was a question of a fact that was not appropriate for summary judgment?
Exactly. And this was actually a 12B6 that was converted to a summary
Right,
judgment.
But there was no opposition to that?
I'm sorry?
No opposition to converting it to summary judgment, correct?
I don't think so.
I didn't see anything.
I don't think there was. But of course, that means that we have less of a record, and maybe that should be taken into account.
So is your point that it should be a reasonable person standard, what a reasonable person would think would be when he or she received actual notice of a triggering event? Is that how that would be viewed?
That is probably how that would play out. And, of course, the second issue is whether there's a contract, and the judge found that there was no contract. It was just an oral discussion. Mm-hmm. However, it's an oral discussion, and there's a student handbook that says, we're going to give you accommodations. Now, Marks actually has another degree, and, which he got an engineering degree with accommodations. This is something that, what is the reasonable understanding of the parties? Schools know how to accommodate disabilities. You can't have a clause that has every potential disability and every potential accommodation, but they understand generally what they're doing. And Ross actually did a pretty good job of accommodating him for 3 years. The question is, and I think this is a question of fact, what happens in the 4th year in that clinical program? Does Ross have an obligation to make some kind of accommodation, or to sort of intervene on his behalf and find a program that will accommodate him? Now, Auburn initially said that they were going to accommodate him, and then they decided, they initially decided they weren't. He went anyway.
Back and forth,
he withdrew, and they said, well, okay, we'll accommodate you, and he went back, and they didn't. So I think this is something that if this is part of Ross's program, then I think Ross does bear some responsibility, and it's at least a question of fact whether he has a claim against Ross for not ensuring that there were accommodations made and not intervening on his behalf.
So you I'm not sure analytically how to piece this all together precisely, but you rely to some extent, at least, on the student handbook. I think for evidence of the contract, I think your opponent says basically, first of all, there's no promise at all to accommodate, actually. And so I think your point in going to the student handbook is, look in the student handbook. We promise to accommodate to the extent we can. But your opponent then says, no, that's never raised below. He's never relied on that argument until the appeal. So first of all, have I got my facts straight? And second of all, if that is it true that you haven't raised the reliance on the student handbook until the appeal?
I don't think that's true, but I can't give you anything specifically at the moment. But I do think an oral contract is sufficient.
And so on that point, your opponent quotes Record Appendix 77 at paragraph 18. Ms. DiPretoro, Ross's admissions representative, stated that Marks would receive accommodations, quote, while at defendant Ross, close quote. And that seems problematic for you. Their point, obviously, is, yeah, as long as you're on our campus, we'll accommodate you if there's a contract. But once you leave our campus, we can't promise anything. That
But-
seems not crazy.
Well, the question is what was the party's understanding? And, you know, that's an issue of fact.
But what evidence is there that there was a legitimate dispute about that understanding?
Well, I mean, when he went to Ross, he didn't, when he went to Auburn, he didn't get any accommodations.
Right, no, but what's I think my question is, the evidence that Ross offered accommodation once he left the Ross campus. What's the basis for a dispute of fact other than his own mind?
The basis is that, based on his discussions with Ross, he understood that he was going to be accommodated during the entire program, not just for 3/4 of it. And, you know, again, that may prevail at trial. That argument may prevail at trial, but on 12b-6 or summary judgment, I think you have to look at it in the light most favorable to Marks. And his understanding was that he would get accommodations all 4 years.
Is Ross correct that the handbook on which your client is relying was published in 2016, but he was enrolled before that?
They may be right, but I think there was a student handbook. You know, that was the 2016 version. I think there's always been a student handbook.
All right, your time is up. I'm just going to check with the panel to see if you have any additional questions. No, thank you very much for your argument. Counselor?
Good morning. May it please the court, Ed Colbert for the defendant Ross. I'll take the arguments in 2 steps as well. First with the statute of limitations argument. And as we just heard, there are the plaintiff is relying primarily on an argument that the statute of limitations for both the misrepresentation count and the Chapter 93A count were told during the period of his grievance process, which began in 2017 and, as he alleges, went through 2021. This argument on tolling of the misrepresentation count was indeed never presented below and was waived. The argument on tolling the 93A count, and I point the court to not only the briefing below, but the hearing transcript, which is attached in the appendix.
So, counsel, if the judge relied on the statute of limitations and it's a legal question whether it was told, why would it be waived?
The issue of the representation count only, we maintain was waived because it was never argued that there's a 3-year statute and it was told during that period. Nonetheless, I think that for purposes of today's discussion, since the 93A argument, which 93A is a 4-year statute of limitations, was not waived below and was presented.
He argues at Record Appendix 72 to 73 that his continuing through the grievance process up to and including the decision in 2021 extends through that time, and this is, I mean, it goes on, but...
I agree that's their argument, Your Honor. I'm simply distinguishing the misrepresentation count, which was never argued below for some reason, versus the 93A count, which they did oppose below on this argument of grievance. Now, as to the grievance, they cite no case law in support of this argument that a grievance process tolls the statute of limitations. Your Honor cited Kaufman. That's the case we cite that says precisely the opposite. There is no tolling in that school principal context where he sought the same thing. My brother just said that he did not believe in our brief. We cited a case that said that, in fact, tolling during a grievance process, I believe as I understood it, at a school, there is no tolling. We cite the case.
Go ahead. Well, so what should have happened here? So there's a procedure, and there's a grievance procedure, and this particular student feels as though he has an actual claim, and he brings it to the attention of the administrators at your client's school or university, and it takes a long time to get resolved. So what is the student supposed to do? File exactly what Attorney Curran proposed, which is you file a lawsuit and then have it stayed while you pursue your grievance procedure?
The Harrington v. Leslie case we cite, which is the federal district court case, suggested precisely that. That case had an employee at Leslie College file a number of allegations, discrimination related primarily, but also went through a Title IX investigation that Leslie conducted. And the Title IX investigation lasted several years, and the argument when the case was brought to the federal district court was, well, the Title IX argument, among other, there were other arguments, equitable tolling, the same one we're hearing this morning, told the statute of limitations, and the court said, no, it doesn't. The procedure is when you know you're harmed, and clearly, as Your Honor cited, paragraph 44 of the affidavit makes it clear that this plaintiff knew that he was done at Auburn and that he was done at Ross in 2017. His paragraph, his words, make it clear that that was known to him. His harm was known then.
Yeah, but
The law is,
I'm sorry to interrupt, but I'm troubled by Justice Henry's question. Why is that a good thing? So in other words, Harrington is a federal district court case, Title IX, so we're not bound by that. But so Justice Henry's making the point, like, we've got a lot to do here, a judicial economy. And also, I know, Title IX, I mean, this is not Title IX, but a grievance process can bring out facts that haven't been brought up before, developing the factual record, making the job of an appellate court a whole lot easier, or a trial court a whole lot easier. And if in fact, this is a question of first impression, I'm not saying it is, but why isn't Justice Henry making a really powerful point? Isn't it a good thing, as a matter of public policy, to encourage grievance processes first?
I would agree wholeheartedly, and that's why lawyers all the time, been doing it a long time, enter tolling agreements when you know that the statute of limitations has run, or you ask the court, if it will do so, for a stay after you file your case. It happens all the time. And when there's no case law out there that protects you as a party from your statute of limitations running on you, you have no choice. There is no case law that supports this argument of grievance. There are cases that say, and I think this is correct too, as a matter of public policy. If you have a collective bargaining agreement where it says in the agreement, okay, here's your grievance process after we demoted you, and during the grievance process, any statute of limitations will be told until there's a decision of whether you're right or you're wrong, and then there's a 30-day process or what have you, and the parties agree pursuant to essentially a contract, a collective bargaining agreement, also supported by, in my opinion, public policy. Here we don't have any such thing. In fact, we have the opposite. We have a plaintiff who knew, frankly, he knew a lot sooner than 2017, but we're calling the triggering event 2017. He knew from the day he went to Ross. He says in his affidavit, 56-paragraph affidavit with 60 pages of exhibits, he says, when I went to Ross, they told me right away they would not be able to accommodate me. I went anyway. His harm was right there in 2014.
Well, but then
I went anyway.
Then he withdrew, and then they said, we'll help you, right?
He withdrew once. They said, we'll help you. He failed his courses again at the end of 2014. There's harm. He went back again and failed again when he thought that he could complete the courses. He was harmed again. He went back 3 times. And finally, the letter came in 2017 saying, you know, that's it.
When he was at Auburn, was he still a Ross student?
Yes, that discussion earlier was correct. He did his classroom instruction at Ross, received his accommodations, which he says in his affidavit was what was promised to him. You will receive accommodations while at Ross. That was the oral agreement, according to him.
That's what I'm saying, but he's still at Ross, albeit at Auburn.
He is. And he says that the oral contract, to the extent, you know, we accept his oral contract, for purposes of argument, was that he would be accommodated while at Ross. And he admits, I was accommodated while at Ross. As to any further contract with, you will be accommodated while at Auburn, even though you're at our school, but you're at a different college in a different location or a different university. He makes no allegations in his lengthy affidavit that was ever promised to him.
Well, tell me this, it may not be relevant, but when one finally graduates and successfully completes the clinical program of 1 year, are you a graduate of Ross or another school? I mean, what's on the diploma behind your desk when you're seeing clients with their animals?
My understanding would be that you'd be a graduate of Ross.
Of Ross.
Yes. It's simply because they don't offer clinical programming at their campus.
One could reasonably infer that one says that you will have accommodations at Ross, that at Ross includes all 4 years, wherever you may be your last year. Or you can interpret it as you do, which is that means only the 3 years at Ross and does not include the 4th year, which could be any one of 22 different locations.
I would say I don't interpret it the way I do. I interpret it the way the plaintiff himself does in his affidavit when he had opportunity to set forth precisely with counsel what his alleged contract was with Ross. And he says, it was a contract to provide me services at Ross, and they provided them to me. And then he goes on, as we just discussed, and says, well, Auburn did too, just not, how I wanted to the first year. And then they started to, because I realized they promised me accommodations too. And then they didn't provide them to me. So what's his contract? It's a moving target at best in that affidavit, and it certainly doesn't rise to the level of what is needed under Massachusetts law to have definitive terms, a meeting of the minds, current intention to be bound, all material terms agreed upon. That clearly is not set forth, despite the opportunity he had in his affidavit to do that. And that's why the Superior Court properly decided.
Is the record developed as to whether any of the other 21 schools could have offered him reasonable accommodations?
That is not in the record.
Other than his wanting to be close to homes, that would have potentially had some side benefits to him.
That's his contention.
Right. Okay.
So in the handbook language he relies on, I know it's 2016, but leaving that aside, because I'm guessing that the earlier handbook language is not that much different, you seem to be saying that the language ensuring that qualified students with disabilities are afforded reasonable accommodations is generalized and aspirational. And I guess I'm puzzled because we talk in terms of the phrase reasonable accommodations in our case law regularly. So I don't quite, and in fact, there are places where the law requires that reasonable accommodations be offered. So I don't understand why that phrase is generalized and aspirational.
It's generalized and aspirational because this is an alleged contract breach. And the case law, and for the reasons I just stated, does not define terms and does not define specifically what the obligations were of either Ross or even Auburn, for that matter, if he was getting accommodations.
We have disability law here, and we say the employer has to provide reasonable accommodations, and nobody says, oh, we can't figure out what that is. We say you have a process where you meet with one another and you hammer it out, or you don't, and then there's a lawsuit or there's not. But we don't say, oh, that's just a generalized aspirational law. There's teeth to it.
Perhaps if it's not contractual, but where it's contractual, Your Honor, I would just point the court to the Brown versus Suffolk case, 2021, Federal District Court, where the same almost identical argument was made by the plaintiff, Brown against Suffolk, using the Disability Services Bulletin with a very similar language about how Suffolk would do their best to ensure that someone who qualified for accommodations received them. Interestingly, in that case, the court makes a nice distinction because the facts are distinguished too. Suffolk had a procedure where by a date certain, a student was supposed to submit a form, a written form, that says, here's my request for accommodation specifically. There would be a meeting, there would be an agreement, a meeting of the minds. These are the accommodations you will receive in these courses, so there's teeth to what you could argue there would have been a potential contract. In that case, the student didn't set forth in the request that he wanted to have his laptop in all of his classes, and Professor Glennon at Suffolk didn't want laptops in his classes. So the students then brought forth his complaint, and the court said, well, you maybe could have gone through it contractually through Suffolk's process of submitting specific requests or accommodations and getting agreement from Suffolk to get them. You can't point to a bulletin that says, we strive to do our best to provide reasonable accommodations to those who want them. The court said that's precisely the type of general aspirational statements, not contractual agreements to be bound.
So if they did enter into an oral contract that Ross would provide reasonable accommodations, is that generalized and aspirational?
If they entered into it depends on what they entered into.
No, just exactly that Ross will provide the student with reasonable accommodation.
No, those terms aren't definite enough for
Even though that's
under the
what
case law.
That's a standard knowable in the law?
If there were an incorporation of either the ADA or some state law for accommodations, a specific reference perhaps to a state law or a federal law, perhaps that could be the terms of a contract, but not a simple handbook statement.
No, I'm not, I've left my handbook behind,
Right,
just an oral contract. And by the way, I'm not hostile to you, I'm cold, so I'm sitting like a cold person. Very friendly to you and everybody else. But if they just had an oral contract that Ross will provide reasonable accommodations, is that enforceable?
I would say no, because it still has the general aspirational terms and isn't specific as to what. The reason I talked about the Brown case is because it was specific that this student wanted to have his laptop in his classes.
I know they all do, and then they say they're paying attention and they don't. I teach. If you walk around behind them, they all freak out.
The example I'm trying to give is a specific accommodation. With Mr. Marks, he wanted extra time, and I gather to be able to, I'm guessing from his affidavit, to take his tests or do some work in a separate room or with quiet, not with other students around. If there were some type of agreement, oral or written, that set that out, in more specificity, and that conceivably could be an enforceable contract, but not just we'll do our best to accommodate.
Answered. Thank you for answering that question. Appreciate it. Any further questions from the side? No? All right. Thank you both very much for your arguments.
Thank you very
We'll take the
much.
case under advisement.
Thank you.
The next case is Richard Savoy versus Geraldine Atkins, 2023-1358. Good morning.
Good morning. May it please the court. Matthew Barak for the appellant, Richard Savoy. The lower court committed reversible error by finding the husband guilty of contempt on multiple counts when he had complied with both the original and later the operative amended judgment of divorce prior to the contempt hearing. Second, the lower court committed error by finding the husband guilty of contempt when there was neither a judgment or an order for which he could be adjudicated in contempt. And third, the lower court abused its discretion by awarding both interest and substantial legal fees against the husband under the faulty presumption that the husband was guilty of contempt.
So, counsel, I sometimes find it helpful to narrow things that are in dispute. So are you challenging any finding of fact by the judge as clearly erroneous?
But we are.
Okay.
We are, because the findings that occurred in this matter are inconsistent with the judgment that was entered.
But like, what specific finding are you challenging?
Sure. For example, the finding of contempt, the finding that the husband delayed the matter.
Wait, there's contempt, there's many different rulings regarding contempt
Yes.
on various things. So can we be a little more specific as to which ones you refer?
I'll give you an example.
Okay.
Item number 1 and item number 2 of the lower court's judgment, paragraph 5 of the original judgment and later the amended judgment required the husband to pay $209,000 by August 16, 2021. That judgment was the amended judgment, which replaced the original judgment, which required a date of July of 2019. The lower court found the husband made the payment of the $209,000 by August 16th, 2021.
Yeah, but can we, you guys are just going around and around on this. It seems really simple to me that he had to, in the first judgment, he had to pay it by a certain date. He pays it 3 months late. There's no dispute about the facts. He was supposed to pay it by a certain date. He paid it late. There's, that inflicted a harm on the wife. And then there's an amended judgment with a new date. That's completely irrelevant to that specific fact of payment of the portion of the house. Why does that matter? We all know the facts here and the harm. So why do you keep coming back to the amended judgment and making what it seems to me like an artificial argument that therefore, because there was this new date that was meaningless, and he beat that date, he wasn't late?
Well, let's go back to what a contempt is. A contempt is a clear and unequivocal command by a disobedience of that command. Here, on 8 of the 10 contempt guilty findings, the husband had long come into compliance. The law is clear.
Let me
So he's
stop.
clearly.
Let him finish. Go ahead.
I don't mind the back and forth.
No, we're going, there's questions on both sides. I just want you to finish your sentence.
Okay, well, I want to make it very clear that the two major points here, to go back to Justice Henry's point, to kind of keep it narrowly focused, either the husband came into compliance of 8 of the 10 judgments of contempt well before this matter went for hearing. And Furtado and the law is clear in contempt. The purpose of a contempt is to find compliance. The purpose of the contempt is to achieve that compliance. And by the time these folks went to a hearing, all of those 8 of those 10 things had been resolved, period. So there is no inconsistent finding on that aspect of the
All right.
case.
They don't seem to be arguing about that, which I think is why Judge Wood is saying you're going round and around, and we want off of this merry-go-round that you all seem to be very happy to be on. We're not doing that. So what I'm hearing you say is that if he's supposed to transfer $1 million by January 2nd, and he waits a year, right, and he's investing that money, and he's, at 6.5%, he makes $65,000, but he gets that money over to her like December 31st, and the contempt hearing isn't until later in January, that he can't be in contempt. And my question is, can the judge do anything about the ill-gotten gains of the money he made while he had that money invested? It cannot possibly be that the judge is powerless on that.
No,
The law's not that dumb.
No, I think that a judge has the ability to assess legal fees and costs. I think
What about the whole $65,000?
well, I think that could be determined. That's not what happened in this particular case, other than a small amount of interest that I think is incorrect under the statute. But what happened here was the judge assessed legal fees under the presumption that Mr. Savoy was in contempt. And I think
Can the judge impose legal fees up to the time that the husband came into compliance?
under a discretionary review of legal fees under Cooper v. Cooper, yes, of course. There's no question. And we're not disputing that. What we are disputing is back to, I think, in the original questions. First, we're disputing the fact that he was not in contempt. Well, I think that's been conceded even by the other side and maybe by the panel. To the extent of what the court could do, what the lower court could do at that point, would be order legal fees. When you go to the legal fees, our issue with that is that it was first, it was unreasonable and excessive. Second, it didn't take into consideration what transpired since the original judgment to the amended judgment to what the parties had done to cure all the elements of both the original amended judgment by the time they went to court. By the time they went to court, they were only down to 2 issues. There were only 2 issues, one of which was...
Well, that's disputed. By the time they went to court, there was only 2 issues.
I don't think it's disputed
Well,
because...
it is somewhat. And also, you had a situation where you had here the special master indicating that, well, we're finally here and things are finally taken care of, but it was basically one of the most difficult negotiations that this particular master had ever conducted.
Well, I'll go back
So back to Justice Henry's point, is the judge powerless to take that into consideration?
No, I think that the judge can't... Well, 2 things. First of all, I don't think it was disputed what they were down to. If you read 422, the wife testified under...
And what's
direct
disputed as to
testimony.
whether or not there was the conduct prior to that amounts
Yes,
to contempt
yes.
or not?
Yes, that
Correct.
That's 100% true. The conduct was in dispute, but I think if you go back, and I think it goes back just...
I see your point.
Yeah, and I think, but what happened, you have to take a look at the circumstances here. I think you have to go back. The husband ultimately saw it when they went to the contempt hearing, exactly what occurred, which was the division of the annuity account. That's what the husband asked for in his filings. There was no bad faith by the husband here over a period of 2 years. The wife, at one point, delayed the contempt proceedings because she took it up to the SJC, the original appeal in this matter. There was a COVID period of time. There was a time when the special master was ill. What happened here in the judgment is ultimately was adopted what the wife presented, but there wasn't a balance of actually what occurred. And I think there's almost a chilling effect that they went to a special master to resolve all of these disputes to end up with a fee award of $180,000 when Mr. Savoy had come into compliance, had done what was even called, back to your point, Justice Vuono, a complicated matter. It involved a special master, involved over 80 transactions of stock. So I think the award of fees on itself, but for the fact that she improperly adjudicated in contempt and put her hand on the scale, should be vacated and should go back to the lower court for a proper determination and should resolve the issue of what transpired during the period of time when there was a judgment, when the judgment was replaced, when there was significant delays by both parties. I think but for the contempt finding, the legal fees wouldn't have been imposed. And in fact, when this went back the second time on the issue of the annuity, there
Judge
were no fees.
made detailed findings here with respect to what happened, what your client did or didn't do.
And those is where we find that those findings are, in fact, erroneous because they're not commiserate with what had occurred over the 2 years. How did these parties go from having 10, 12 elements, over 80 transfers of stock, to going to the day of a hearing after being up and down the appeals court to having everything essentially resolved at that point in time?
So the wife argues that you never complained about the scope of the contempt hearing below. Where in the record did you object to the scope?
Well, first of all, the special master indicated that there were only 2 issues. Second of all, the judge's trial order for the contempt hearing indicated that there were only 2 issues, the BOFA account and the issue of the coins, which my client had paid back in 2021. The judgment that entailed, which was supposed to be a 4-hour hearing, which turned into a 3-hour evidentiary trial, is a runaway judgment. In other words, my client was expecting at the end that the BOFA account would be resolved, that the fees would be done. There was no notice or opportunity at any point that this would end up in a judgment of contempt on these other 10 items because they should have been confined, and the judgment should have been confined to what was noticed in the hearing under Kavanaugh and his progeny. There was no...
But even if you get that, even if you win that point with us, I still don't quite understand. I'm presuming your client is concerned about money. I mean, maybe he doesn't want to have this label of contempt, but what does it get him? He still has to pay any harm he caused or any, the judge can order him to disgorge, whatever benefit he had. and the judge can still award the fees that it took the wife to chase him down.
I think it gets him a rehearing on what's reasonable for the fees. I think.
And so you guys you'll keep fighting and you'll be back here again?
I would hope not, but I think that, I think
Well,
he
is past
deserves.
prologue, because as I told you, we're not going on the roller coaster with you, or the merry-go-round, excuse me. Let's
And I
not change amusement
appreciate
park
that.
rides.
I like the roller coaster better.
There you go.
I get dizzy in the merry-go-round.
Justice Wood has a question.
Yes.
here.
I have a larger conceptual question based on what I think you're already conceding. That Cooper, you said this way back at the beginning, Cooper authorizes the payment, the awarding of fees. For example, for my first, we can have one simple example, because analytically it applies to everything. The $209,000 late payment. Okay, you're supposed to pay it according to Judgment 1 on this date. You paid it 3 months late. Okay. And so the hassle of collecting the 12% interest for the lateness of that is legal fees that under Cooper, the judge is allowed to award. It sounds to me, what I'm hearing you say is, yes, the judge under Cooper is allowed to award the fees, but it was error to hold him in contempt because he paid those fees before the contempt hearing. And you're saying, this is the part I'm really not understanding, if we were to undo the contempt finding and send it back and authorize the judge to order fees for the hassle of chasing down all these things, it would be a different result. Why would it be a different result? Because it's still the same thing. My lawyer has to chase you down for the 12% on this and then the other 9 things. Why is that going to help anybody?
I don't agree it's the same thing.
Okay,
I agree with and here's why. Because the statute says there's a presumption of fees absent a written finding that there shouldn't be those fees. So this contempt statute itself in the probate court requires fees, okay? So if it requires fees. Once you take that thumb on the scale presumption away, I think it changes things. Because at that point, the judge should consider, and what we're really asking for is to go back on the legal fees and to go back with requests that the judge consider the fact that these parties over a period of time went up and down the appeals court, that they used a special master, that the husband paid for the special master, which we're not challenging, that the fees related, $130,000 of these fees that were awarded related to a judgment that is ultimately null and void. And we haven't discussed that, but I think that's an important point that the judge should weigh. That Judgment 1 was extinguished by Judgment 2, and the majority of these fees requested relate to that. That also, the judge should also consider the actions of both parties in making fees. The fact that this was delayed not by Fidelity for a period of time because their Fidelity accounts, for no fault of my clients, was done. And that also, regarding the excessive nature of the fees here, which is part of our brief, that having 4 attorneys versus 1 attorney under a case where there's multiple billings for things like strategy, things like on a contempt, that there should be some parameters around a hearing related to what occurred here without putting the thumb on the scale
Right,
regarding
so the
contempt.
wife argues, though, that your client waived any arguments concerning the specific billing entries or the 2 people having a meeting with one another by not raising that issue below. What do you say to that?
Oh, he raised it in his findings. He raised it in his proposed findings. So I don't agree with that. I think if you review his proposed findings, he raised the double billings. He raised the nature of those findings and those fees that resulted. But I think ultimately, to the panel, that's what we're looking for. We believe we believe he has not had an opportunity because the thumb was placed on the scale.
So you're saying if we take away the finding of contempt on certain issues, then that takes away a presumption of fees?
Correct.
Okay, but do you get if the judge still decides to award fees, do you get a different result?
I think we do. I think under these facts and circumstances, when he had come into compliance well before the hearing, when she adopted the BOFA account suggestion that he made, when you go through the fact that everything was resolved essentially through the special master, I think it's reheard. I think the fact that the judge made a major material mistake here and awarded fees based on a presumption that's faulty, which is a game changer. If we were talking about 20...
Your time is up, so...
Thank you.
Question been answered for you, yes. Thank you very much for your time.
Good morning, and may it please the court. My name is Robert O'Regan. Joining me this morning at council table is Heather Cahill. It's our privilege to represent Geraldine Atkins before the court. I'd like to begin with trying to draw the panel into what was going on before Judge Black during the 11 status conferences.
Well, before we do that, I really would like to right-size the case. So is he correct that the contempt finding should not have been entered on paragraphs 1, 2, 3, 4, 7, 8, and 10? Because he had come into compliance. Does it seem like you said that in your brief?
It does more than seem like we did say
Okay.
that in our brief. There
So
is
Okay.
a technical error in the judge's judgment, where Judge Black made an adjudication that at the time the judgment entered, Mr. Savoy was then in contempt. He was not then in contempt on the items my brother raises. We contend he still remained in contempt, for example, on the Bank of America pension. That does not mitigate at all what went on here at the instigation of Mr. Savoy. The entire thrust of Mr. Savoy's conduct was to pretend that Rule 62G of the Rules of Domestic Relations Procedure doesn't exist, was to pretend that 2 motions for stay pending appeal were never denied, to pretend that he did not need to comply with a judgment of this court or the amended judgment of this court. Bearing in mind, and I hate to travel back in time, but bearing in mind, Rule 62G came into existence because after the adjudication of a property division, it was often impossible to have a recipient of a marital asset receive it. Why? Because an appeal and all of that would, to be too vernacular, muck things up. And so Rule 62G created a clear exception without relieving anyone of an opportunity to get relief by a motion which was denied by the trial judge and by the single justice.
I think I'm following you, and I think the point you're making is a sound one, that he couldn't wait. This notion that the new judgment replaces the old judgment, and this new deadline is the only thing he has to comply with, and therefore it's as though this first deadline never existed. And so if that's what you're saying, I understand that and am sympathetic to that. But he's saying that a finding of contempt is a very clear definition. It has to be you have to be in disobeyance of a clear court order by the time of the contempt hearing. And they got at least all but the BOFA and the coins sorted out before that hearing. And so I think that's where we're struggling, or at least I'm struggling.
Well, may I refer to the appendix on 2 points now, as long as I'm here? Yeah. Number one is, we cannot find proposed findings of fact by Richard Savoy with respect to attorney's fees in the appendix presented. And so I'd ask the court to disregard that portion of my brother's argument because that is not before the court. Second, my brother did not include a very pivotal exhibit from the proceedings below. We did in our supplemental appendix. It was trial exhibit number 2. Trial exhibit number 2 lists each of the assets that were required to be divided and the date of compliance. And from that document, the panel will see how late Mr. Savoy was in reaching compliance. There is a point that is made that he couldn't comply with respect to fidelity, the fidelity transfers. Well, the argument there in my brother's brief is there was some sort of stay put on by Fidelity between December 2021 and May 2022. Initially, I was blamed for that, which gives you a sense of what the temperature was in the trial court on this case. Turned out that was not true. He's never explained why until December 21st, 2021, he didn't comply with 2 judgments to make those transfers. Now, somebody might argue, well, you know, if I make these transfers before an appeal, how am I going to get it back? Well, 2 points. Number one, Rule 62G doesn't give you the chance to decide that unless an appeals judge or a trial judge give you a stay. And number 2, there's an automatic stay in all divorce cases. So nobody can dissipate or change assets until the case is over. So all of the things that have been put in place to protect Geraldine Atkins from the torture she was put into at her age and the stress, Mr. Savoy said he can get away with.
Right, but sorry, I feel like I'm not making my question clear enough. Accepting your point that the delay here was caused by Mr. Savoy, or the overwhelming portion of the delay was caused by Mr. Savoy, and accepting that it was intentional, I don't know if that matters, but accepting that it caused harm to your client, accepting all of that, what do we do with his argument that, yes, but technically I was, or not technically, really simply, I was not in contempt for 8 out of the 10 things because I got that all done late and painful to your client, but before the contempt hearing, and so the judge made an error in finding me in contempt, putting his thumb on the scale for the attorney's fees award, and therefore, if you take the thumb off the scale, the attorney's fees would be less. What do you say to that argument?
Point number one, this was a very careful judge whose findings indicated she very carefully went through painstakingly every argument Richard Savoy made below. None of the findings of fact are challenged in the brief. Portions of the judgment are, but the underlying findings are not challenged. So, with respect to each of the division of assets, each asset to be divided, Judge Black made a detailed set of findings with respect to each asset, and at the end of each of those sections, Your Honors will see there's a line that says Richard Savoy was in violation for not completing the division of asset within this time. Richard doesn't say there's anything incorrect with that finding, nor could he. How do we know? Because the stipulation on when and how there is compliance was the exhibit. So it is documented.
Did the judge, though, rely on the presumption that fees would be awarded if there's a finding of contempt? Because that's what he's arguing. He's making a very technical argument that might or might not be accurate, but he's saying that if the judge relied on a presumption that the judge should not have relied on, we have to send it back.
If Your Honor reads the
You
way...
get the same result, except you're going to spend more money, but that seems to be...
I believe a fair reading of the judge's description of how she awarded legal fees indicates that the decision was based on what was actually done to bring about compliance, when and how. And it did not rest on the fact, and I do not believe there is a sentence in there that says, in effect, because I have adjudicated contempt, under the statute, I must award attorney's fees, and therefore, this is the number I arrive at. To the contrary, we read her analysis as being very detailed and thoughtful to say, leading up to that point, she went painstakingly through everything that it took to bring about compliance. And so I don't think it is a fair reading of the decision on attorney's fees to say, frankly, it matters whether the judgment found contempt or not, because the findings say there was clear and unequivocal violation of the order, and if the court will look at the chronology in Exhibit 2, you will see he ran it right up until the time that the contempt trial was about to start.
Can you just give me your record site for, I'm trying to find really quickly, Exhibit 2. I was in your
It's in the supplemental
appendix. Yeah.
appendix.
Yeah.
And it is, I want to say, supplemental appendix, page 5.
Okay. I'll find it. I'll find it.
It's supplemental appendix,
I've got
page
it here.
5 to, I think, 8.
Yep, I've got it. Thank you. Thank you.
So the husband argues that he cannot have been adjudicated in contempt regarding the Prothena stock and the Bank of America account because the special master's recommendation was only incorporated into a court order for the first time within the lower court's contempt judgment. So what do you say to that?
Again, we have a position where Mr. Savoy would have this court adopt a view that what he actually did in the proceedings doesn't count. So he actually did disobey Rule 62G and the stays. He actually did sign an agreement to abide by what the special master recommended and then tried to not comply with it. The issue with the notice, with the complaint for contempt is the defendant on fair and adequate notice of a violation. Those proceedings and the resolutions of property division were all encapsulated in what was referred by agreement to the special master. He agreed to comply with what the special master recommended, and then, in yet another example, he said, I'm not going to do it. Frankly, and I mean no disrespect to the lower court, to get to the outcome of parties in this kind of a dispute, the word contempt may or may not matter. It is whether people can receive what they're supposed to receive, when they're supposed to receive it, and not be put through torture to get there. And that is what happened here. So we have an example with respect to that stock where they go to a special master who was supposed to work it out. We know from the report, and we know from the judge's findings, another episode in torturing, changing the rules of the game. I don't think it is proper, nor should this court condone anyone voluntarily participating in a procedure with a special master when there's serious contempt charges, agreeing to a disposition, and then after that come back and say, you can't hold me to what I agreed to because you did not give me notice ahead of time that I would be bound to what I agreed to. That's what he's saying. That can't be the outcome.
So he argues at page 42 of his brief that we should take judicial notice of the fact that he was found not guilty of contempt regarding the Bank of America account in a subsequent hearing below. What do you say to that?
Number one, he hasn't put that before you for you to take judicial notice of it. Number two, if we were to get to that point, it would be another round of appeal on what went on. And I would use that as an illustration of the time and torture that this is involved. We're dealing with a pension account. If you read the record and the briefing, Mr. Savoy claimed in the course of the contempt that the nature of that asset had changed. He was given an opportunity to call that to the court's attention after the amended, when the amended judgment of contempt of divorce was being entered, and he didn't do it. He was found guilty of contempt because that was the nature of the asset. Now we get, after long, difficult contempt proceedings to bring about compliance, I would say, in general, the decision to hold somebody in contempt, even if there's disobedience, is still discretionary with a judge. Were we to have appealed that, I would be arguing that the judge abused her discretion in not finding him contempt. But when you have a client who is 82 years old and been through this, there's only so much you can do. So judicial notice would not be proper for that.
Is there an appeal pending of that decision?
No. But judicial, and in any inference from that outcome would be an incorrect inference. It's not part of this appeal.
I just one more question, which you may have just covered, and I apologize. There were two matters that were outstanding at the time of the contempt hearing. I think it was the BOFA account, which I think is the pension account, and the gold coins. Yes. And so at the time of the concept he keeps relying on, your opponent, is at the time of the contempt hearing, I had done everything. But there are two things, apparently, I can't remember, he hadn't quite done. And so remind me, did the judge, after that contempt hearing, find him in contempt? You might have just answered this, but did the judge find him in contempt for the failure to do those two things?
The contempt judgment, the findings of contempt include contempt on the two things that he was not in compliance with.
Right. And so this conceptual rubric we're working on, that he complied before the contempt hearing, in fact, doesn't apply to at least two things. So there are at least two instances in which he was in contempt by his own definition, which is the definition. And so what consequence of that? So even the judge, I think, correctly put her thumb on the scale for those 2 points at least. And so is it a degree of thumb pushing or is that concept correct?
I don't think thumb pushing belongs in administering justice, so
Okay.
I would back away from that reference.
Fair point. Yeah.
I would say that if you look at the record and the timing, Exhibit 2, everything Mr. Savoy could do to delay and obfuscate, he did. And what he couldn't delay and obfuscate anymore was left for the judge to decide. She knew it, everybody in the courtroom knew it, Mr. Savoy knew it, his lawyer knew it. And so from that point on, even on the attorney's fee issue, it was an attempt to further drag things on. He made the point, and I agree, a 4-hour hearing, 2 hours each side on attorney's fees turned into a 3-day trial. How does that happen? And none of the record from that, and none of the information on the attorney's fees that he's challenging is before you cited as an error, clear, plain error in the judge's findings. So for my brother to argue that the judge was incorrect in exercising her discretion based on the facts she found that are not challenged, that the attorney's fee award she made was correct, for that to be challenged on appeal is inappropriate and is not adequately protected below.
Okay. Thank you
Thank
very
you.
much. Thank you both for your arguments. We'll take the case under advisement. The next case we'll hear before we take a short break is case number 2024-0609, Pamela Cyr versus Katherine Smith. Good morning.
Good morning. May it please the court. My name is Stephen Griffin. I proudly represent the appellants, Joyce Halupka and Pamela Cyr. We come before this court seeking a ruling that the land court erred in entering judgment after a one-day bench trial dismissing appellant's complaint for specific performance, and respectfully request that this court reverse the trial court's decision and order that the appellee convey title to the subject property to the appellants in accordance with the terms of the subject contract, paragraph 1 of the subject contract. The trial court's decision should be reversed for 3 reasons. First, the plain, unambiguous language of the contract gave appellants an enforceable option to repurchase the property at a defined price when the appellee decided to sell on July 19, 2021, which was within 4 years of the agreement. Appellants exercised their option in a timely manner within 4 days and were ready, willing, and able to perform under the agreement on September 15, 2021, but appellee refused to perform.
And that's the $2.8 million offer.
No, that's the 2.5 million, no, that's on July 23rd, my clients exercised their option right under paragraph 1 of the agreement.
Which was lower than the 2.8 million offer.
It's lower than the 2.8
0.596.
potential offer, correct.
Okay.
So just to, again, to right-size the case, so I don't see that you're challenging any finding of fact as clearly erroneous. Is that correct?
I don't think there's a real dispute of the facts, Your Honor. I agree.
And you agree that Smith never actively marketed the property in 2021, right?
She had not marketed the property, nor could she under the terms of the agreement, because she had to wait 30 days after giving my clients notice of her decision to sell before she could market the property.
Right, and you're saying that the notice she gave on June 22nd that she was considering selling is not enough to trigger the agreement, is that right?
Yes, Your Honor. I think that the trial court found that very clearly, and we did not contest that. We felt that at that time she was considering selling the property, and over the next month or so, my clients tried to talk her out of it. Please
Right.
stay, reconsider.
But they're arguing, or she's arguing that you did not rely on the July 19 letter during the trial, but only after you put it in your proposed findings of fact and conclusion of law. Do you
That's
disagree?
incorrect, Your Honor. We tried that case with the understanding that July 19th was the triggering event. So that's a straw man argument that's being advanced by the appellee. It was clear that between June 22nd and July 19th, that Ms. Smith was considering selling the property, but it wasn't until July 19th that she notified my clients that she had decided to do so and said, please confirm that I have now fulfilled my obligations under the purchase and sale agreement. We believe...
The judge found that on July 19th, she accepted part 2 of the proposal in your client's July 14th email, that she accepted their request that they be given, that they be excluded from the broker agreement and be given an opportunity to repurchase the property at an amount that was 5% below any third-party offer, which I think they were presuming 5% was the broker's fee. Why is that wrong?
Because, Your Honor, for 2 reasons. The trial court determined that that constituted a modification, these 2 emails, July 14th from my clients and the July 19th email that you just referred to from Ms. Smith reply, said that those 2 constituted an enforceable modification. They didn't. I disagree, Your Honor, as a matter of law, because number one, a modification, like a contract, requires mutual assent, present intent to be bound, and consideration. None of those things were present at that time. What my clients, if you look at that email from July 14th that my clients wrote, they made clear that they were considering offering $2.8 million.
No. See, this is, again, we're not going to obfuscate. There are 2 parts to the July 14th email. One is the $2.8 million. The second, which I don't see you deal with, and you can not answer my question and leave us to wander on our own without your input, or you can answer the question. The second is that the judge was saying that when they said, exclude us from the broker's deal and let us offer you whatever your offer is minus 5%, and the judge is saying that second part, that she accepted it. And I'm asking you why that's wrong, because I don't see you target that in your brief.
Because at that time, there's no consideration whatsoever for this purported modification. The agreement at the time,
Well,
Your
I think
Honor,
there's, again, I hear what you're saying about the modification, and I will ask questions about that to your opponents. But the judge seemed to be saying that you had a written offer and a written acceptance, and that's a contract.
the judge, I believe, is saying that, but I think the judge is wrong as a matter of law, that is not...
What's your best case for that?
Well, number one, there's no consideration. What he's saying is that led to a modification of the agreement. And this, I think, is a very big opportunity for this court to explain something to the bar, that there is a difference between a bilateral contract and a unilateral contract when it comes to modifications. At the time of this July 14th email, the contract was a unilateral option contract. My clients had the right to repurchase the property. It did not become a bilateral contract until July 19th, or July 23rd, when my clients accepted or exercised their right to exercise their option. That was triggered on July 19th. At that point, it ripens into a bilateral contract.
Right, and I
So
think
a
the trial court would say, and this was the strategic error your clients made, right? If they had immediately said, hey, we have this side agreement, and we really only have to pay you $2.5 million plus 1% compounded annual growth rate, but, you know, we're friends, so we'll offer you more, we might be in a different place. But they didn't. They were, one could argue, nice, and that Ms. Smith really was, I don't know what she was thinking, but your clients were nice, and they offered the $2.8 million. And so at that point, they've sort of lulled her into thinking, okay, we're not following that side agreement. And so where's the part where, and you're relying on this, well, this is a unilateral right, so she can't change her mind. But you don't deal ever with the trial court judge's finding, which seems quite accurate, that that was never the intent of these people. That they were all trying to get along, and they had this plan about how they could still control the property if she decided to sell, but that nobody was ever imposing this draconian, you can't change your mind.
I think, Your Honor, that the parties, what came out was both Ms. Smith and my clients in the June and in this period of time had forgotten about this side agreement that the judge refers to it as.
It seems hard to me to understand, so then your clients can get away with that, but she can't. I mean, this agreement, nobody should have, she was foolish to enter into this agreement if she cared at all about money. This agreement was so advantageous to your clients, to the tune of tens, if not hundreds of thousands of dollars.
As it turned out, given the market conditions, it turned out to be favorable to my client, but my clients were very clear in the negotiations that they required this agreement for her to sign.
Right, they were very forthright about that, but where's the part where if they all forgot and then she's like, oh my God, you know, you're reminding me of this and I don't want to sell on those terms, why can she not change her mind?
Once she decides to sell, the agreement says once she decides to sell, for any reason, appellants have the right to purchase the property for $2.4 million plus the 1%.
What does it mean to decide to sell? Go ahead.
No. You asked the same question.
I mean, what does that mean, decide to sell?
Well, decide. It means to make a definitive, and I think I've cited the
Well, it's not definitive because she's
dictionary.
not selling anymore.
Right, but I think, and Your Honor, if she had negotiated, her lawyer, she had an experienced attorney, my clients had experienced attorneys, if they had negotiated what would have Ms. Smith would have the right to change her mind after she decides to sell and my clients thereby exercise their right, that's rewriting the contract. What we had, and it's just not there. Had they intended to
There's
include
no
that?
rewriting the contract. The contract still exists. She just said, wow, that's harsh. I mean, don't get me wrong. She's got her own problems, which is the longer she holds this, I don't get your client's motivation at all. The longer that she holds this property, the bigger their profit is. I mean, just beaucoup money, except maybe they don't want tenants in there. But, you know, and the longer she holds the property, I don't know what she's doing here. The longer she holds the property, she's giving away hundreds of thousands of dollars where she could cut her losses and get a different beachfront property and then make that profit. And they'd all be away from each other. Seems like that would serve all of their interests, but they're, again, like the last people, but maybe more here, it's mutual, they're just locked in litigation to make each other miserable.
I think my clients believe that this contract should be enforced as
They
written.
still get that. They still get that.
They think that she decided to sell on July 19th. That gave them the absolute right to option to buy it on which they exercised on July 13th. And set a closing date and a formula price. So
Justice Wood had a question for you.
So focusing on Justice Vuono's question, decide to sell. The judge, I think, cites two cases and a principle that's really important in this kind of contract that you never wrestle with at all. I'm looking at page 8 of the decision, where you're talking about an option contract. Because it's such a powerful thing, we must, Sudbury v. Scott, because an option contract creates a unilateral right in the holder of the option to compel performance exclusively for his or her benefit, courts must construe its language strictly. And to that end, all essential terms in an option must be definite and certain. So when I apply that law to this contract, which seems very one-sided and powerful, and that specifically to the decision to sell, as Justice Vuono is focused on, I don't think that we have a situation where she has decided to sell when she did what she did. She decided to put it on the market. That's not the same to me under this gloss as decision to sell. And I note that you didn't address that at all. What is your answer to that?
I believe, Your Honor, that there was no factual dispute that she had decided to sell. I think she acknowledged that at trial, that her actions supported that, She hired a broker.
That's actually helpful to me. Do you have a trial transcript citation for where she admits that she had decided to sell as opposed to put it on the market, to test the market to see what it's worth, and then decide at that point, depending on what I can get, well, maybe I'll sell it then?
I think, Your Honor, the clear intent of this contract to say that that is her option under this contract is to, number one, decide to sell and then but leave herself the option, that would render this contract illusory. It's interpreting this in a way that doesn't enforce the intent of the parties. The intent of the parties was clearly that when she decides to sell, that my clients have the option before it goes on the market, So she had decided to put it on the market.
It never went on the market, right?
What's that?
It never went on the market.
She couldn't put it on the market under the contract. She had to wait 30 days. And litigation was filed within that 30-day period, and a lis pendens was awarded.
But let me, well, you say that intent doesn't capture the intent of the parties. So the July 14th email from your clients, if you decide to list, please allow us to meet the offer you would accept minus 5%. We all understand what that means, the exclusionary list. But it seems that, and I guess you've answered this, they had forgotten about the assignment, because if they had an intent from the side agreement, this line, if you decide to list, please allow us to meet the offer, is completely contrary to the intent of that agreement, right?
Correct, Your Honor.
Okay, so their intent now is completely different than their intent was then. And if their intent is, in fact, if they understand the powerful content of their original side agreement, it seems to me they've realized we might have made a mistake. We need to give her a better deal, or she's never going to decide to sell, and we're never going to have a chance to get this property because she's forced, if she decides to sell, we have a ski slope. She has to sell it to us. She can't change her mind, and it's going to be below market now. So they might have said, rationally, in this moment, oh, we actually need to change this to a more equitable arrangement. And that's what they're giving up. That's the consideration. And then when she accepts that, yes, I'll do that. I'll put you on the exclusion list. She's getting something. That, to me, is conceptually consideration for both sides and much more rational in light of the crazy one-sided agreement that they had both agreed to that gets nobody anything. Do you have an answer to that?
I think it does get my clients something. It gives my clients the control over this house that is immediately
the original. So you mean the original agreement?
The original agreement.
Right.
And which was sold to the appellee without at 5%.
Well, I get that. It gives them control. I'm sorry to. Could I just finish my
please
question?
finish.
I apologize. I understand the original agreement gives them lots of control. What I'm saying is it also creates a problem that if she understands it, she might never sell because, and that to them is a cost because she's going to be forced to sell at below market. So she might say, eventually figuring this out, oh, I can't ever sell. And so they may have made this new offer on July 14th to recognize that. So yes, they get a benefit from the original offer. They also get a detriment from the original offer, forcing her to be locked in forever if she wants to sell above market. And so that's what I'm asking you about.
Well, what I'm suggesting is that offer, the discussion of 2.8 was merely, we may offer you 2.8 if you give us all the furnishings, all these things that aren't part of the agreement, that these consideration that we're not entitled to under the agreement. And Ms. Smith said, no, $3 million. They said no, and we had no deal. And
Thank you.
Thank you.
Could I just ask one question, though?
Sure.
On our Record Appendix 64, which is a July 24 email, which is after your client sent the lawyer letter, she says, it's in the middle, in the very dense first paragraph, but she says, when I decided to actually see what the market value was by listing it. So even here, she's not committing that she decided to sell, is she?
I think she had, our position is she had already committed to sell by the plain language of her July 19th email.
And what specific language? Because she says, I will be putting the house on the market?
This confirms their conversation clearly that they had on July 14th.
Right, but we don't have the real estate broker contract, and we don't know how committed she was to sell by that contract, right?
We don't have the real estate broker contract, but we do have the email you were just referring to where she says, we hired a lawyer, we worked all week to get the house ready for photos and showings, we spent a lot of time to move forward, et cetera.
Right, but you're still not, I mean, unless the contract says you're obligated to sell, she's not necessarily obligated to sell, right? Usually, if you back out, you might have to pay a broker fee because you backed out, but.
I think that the contract says if she decides to sell for any reason.
No. There's no real estate broker contract. We don't know what her obligation was to actually sell. And what we have here are statements about seeing the market value, but that we can we'll leave it there.
Yeah, anybody can hire a broker and they don't have to sell.
Right. Okay. Thank you very much. Good morning.
Good morning. May it please the Court, Attorney Steve Schauer for the appellee, Katherine Smith. I think we do need to focus on what this is all about. It's a complaint for specific performance, which they're seeking equitable relief. And in the case that I cite, Gallipolt, as the claim for specific performance is axiomatic that one must behave equitably in order to obtain equitable remedies. Judge Smith.
Where do they, I mean, they wrote a very clear contract, and they were super generous with your client. I mean, she was entitled to $2.5 million plus like 1% CAGR, and they turn around and offer her almost $300,000 more than that. Like, where's that not equitable? I mean, and the longer, but your client is cutting off her nose to spite her face. I don't know that she knows that, but the longer she holds this property, the worse this deal is.
So to address, Your Honor, to suggest that this agreement is clear by any stretch of the imagination, I would think, and as Judge Smith went through, with the review of the testimony, the documentary evidence, everything, Judge Smith wrote a very detailed 15-page decision, and to suggest that this was clear agreement from the, and justices this morning have now questioned, what does decide mean? I would suggest, unlike other cases that you've heard today even, triggering events such as statute of limitations, the death of someone, whatever it might be, to suggest that just the word decides for any reason, I agree with Your Honors that that word decide is really completely in control of the appellee throughout the process. And to remember that the purpose really of this side agreement, this agreement, was not so that they could buy it back with a CAGR, which Judge Smith also states throughout the trial that he has no idea what that means, but that the real purpose, and it was in the testimony.
I don't know why he doesn't know what that means. It's compound annual growth. It's 1%. You know it's less than 5% because that's what paragraph 2 provides. I mean, I don't know how that's not clear.
Fair enough, Your
If
Honor.
she didn't know what it meant, then she should have asked.
Fair enough, Your Honor. But my point being is that the real purpose for the agreement, when they entered into it, was for that the appellant could maintain control over who their neighbors would be. No matter what happens, Ms. Smith, the appellee, will remain in possession of that property, and when she does decide to sell, they then may have the opportunity to determine who their next neighbors might be.
Okay, so I want to
That's
break
the purpose
this
of
down
the agreement.
Right, so, all right, and so they don't want somebody who signs a contract and then reneges. So they don't want her there anymore. And she's given them this perfect opportunity because she's literally says at RA 62, I will be putting the house on the market at the end of July, which most people, I mean, you can renege on a real estate broker contract, but it's, you know, not, then she's going to have litigation with the real estate broker. I mean, she doesn't use the word decide, but otherwise, I mean, she's saying I'm selling.
I understand, Your Honor.
Unless she's behaving irrationally, she's saying I'm selling, and so then they're saying, well, we're exercising our right.
I go back to the same argument in regard to the equitable nature of what specific performance is all about. Your Honor,
You started to say they didn't behave equitably, and I'd like to hear how that was. How did they not behave equitably?
it's funny, Your Honor, that you used the word lulled into earlier in your questioning of my brother. So in two aspects of this, to remember that the whole purpose of this agreement was to ensure that the appellants have the right or have some say as to who the neighbors might be. That's the real purpose. So as long as they, maintain that, they then use the triggering event. And again, there's no definition of what a triggering event is. Death might be, statute of limitations, as you heard today. But this triggering event that they've used, and I do disagree with my brother, who stated that it was throughout the trial that they were using the July 19 as the triggering event, where throughout the litigation, that's why I gave the supplemental record appendix that used right from the very start of this litigation with the filing of the complaint, that they used conversations in June of 2021 to be, quote unquote, this triggering event.
Okay, so I'm going to pause you on that. Where is there a factual finding from the land court judge that was the triggering event? Because it seems like the judge is using the July 19th email as the triggering event.
Absolutely, Your Honor. I made the argument. I thought it was very clear. I made the
You
argument.
didn't make a finding of fact, so aren't you out of luck at that point?
Well, I have it in my post-trial brief that they didn't address and that they did find the July 19th. But then I go back to your language, the lulled, and that's where I go into the equitable argument again, that they then submit the email that offers the 2.8, and then the second part being put us on the exclusion list, being lulled into that agreement. The appellee, in her email response, accepting their terms, says, okay, that's what I'm going to do. I'm not going to take your 2.8. She was lulled into this. So how could that be a triggering event?
What language are you relying on? Because the judge, all she says is that she's going to put them on the exclusion list. I don't see her saying, I agree you can buy back at market value minus 5%. That's point one. So what literal language are you relying on?
The offer, in the first email, the offer.
Yes, you're talking about Record Appendix 61.
If you decide, please allow us to meet the offer, you would accept minus 5%. She accepts that term and says that I will place you on the exclusion list.
Why does her saying I'll place you on the exclusion list mean that she's accepting that she's going to allow them to meet the offer minus 5%?
Well, there's no other reason to put them on the exclusion list, but for the fact that if they're on the exclusion list with that term being part of the accepted offer, therefore the appellee, once she does receive an offer, she's going to put it on the exclusion list. Another offer comes in, they'll meet it, minus 5% for the commission, the broker's commission, as you've made note of. It's a part of her acceptance.
So on Record Appendix 64, she literally says in the first paragraph, when I decided to actually see what the market value was by listing it. Why is that not a decision to sell?
I think what happened, and again, Justice Henry, you referred to this lulling, the nature of lulling the appellee into this position where they make this offer, she accepts it, and then all of a sudden she's hit with this notice to exercise rights. It's almost as if the rug was pulled out from under her.
Right, so his point, though, is there's no consideration what did they get out of it? Because her putting them on the exclusion list saves her a 5% broker's fee. It doesn't get them anything.
Well, I think as court decisions are very clear, the level or how appropriate consideration might be is not for a court to decide. The mere fact of a promise in exchange for a promise can be viewed as consideration.
And just that it's settled, and so that's then they've got a method to set a price. You think that's sufficient consideration?
I think the consideration was the promise that in exchange, so that the appellee would be left with, I would have to sell it to you with an offer that comes in minus 5%. I would have to give you the opportunity to buy the property back. Whether I want to consider another buyer, maybe another buyer would not be concerned about it at the same offer price. Maybe a buyer might want something else included or not included. It might be better terms in some way. But she's saying if they meet the offer, minus 5%, she would then have to sell it back. I think there's more than adequate consideration. And as Judge Smith found, even the underlying agreement may not even be necessary to look to at this report. It's 2 emails. It's a quote unquote, it's 2 emails. It's a contract. It satisfies the statute of frauds. So I think it's clear that Judge Smith considered it a contract. I think by definition of any of the case law cited in the brief or whatnot, it is a contract. It has consideration. It's got acceptance. It's got the offer. It satisfies everything that you would want for that contract. And again, I go back to the equitable argument that, so she follows up with that. I had decided, okay, but she decided based upon their new offer that came in
Right. So,
in
but
July.
I think their point is the entire purpose of this agreement was to make sure that they had a good neighbor that they got along with. And when she reneges on or tries to renege on this side agreement, they don't want her. They're exactly not getting the benefit of the bargain. They're in fact getting this horrible situation for years and years, potentially also with her renting to tenants or, weekly vacationers. They're losing the entire benefit of the contract.
But, well, they have to, the fact that the agreement was entered into by both parties, your honors have already addressed the fact that, yes, this was a very poor agreement. My client probably should never, not probably, but should have never signed it.
If she cared about money, yeah.
But that her attorney was the primary focus on it. The appellant was the one who came up with the CAGR. I think acknowledged, yes, we may know what compound annual growth rate is, but it's very uncommon in real estate transactions to value property at that rate. But she did sign it. And I think Judge Smith bent over backwards to satisfy the equitable nature of what happened here in this case, that the agreement still exists. And that may even be contrary to what I put in my post-trial brief. I do believe that they ignored the time period between what they considered to be the deciding, that triggering, I used the triggering as they did in June, and that they were late in getting their offer in or to their notice of exercise of rights or whatnot. The judge did not agree with me with that. But in reflection upon reviewing that 15-page decision, quite frankly, I think Judge Smith did what judges are supposed to do. He did exactly what was expected in analyzing the testimony, the documentary evidence, and when he made his determination, he had that equitable nature of what was going on here as the forefront of this, so that at the end of everything, at the end of that 15-page decision, that contract, no matter how bad it is right now, is still in existence.
And getting worse for your client every day, but he argues that if your client understood the agreement to have been modified by the exchange of emails, then but she then says, have I fulfilled my obligations outlined in the agreement, that shows that the original agreement still controlled. Paragraph 1 even.
Not from her perspective. She's now responding to that email, okay, I accept your new terms, your proposal, your modification. And again, I would suggest
that the agreement no longer has force.
Excuse me, I'm
So
sorry.
that the agreement no longer has force, any force or effect is your point.
Exactly. And as Judge Smith also does indicate that again, I think there's some not confusion, but the E. Van Norden company case has very little information on what type of modification was occurring in that case, that whether it was in writing or not. This modification, as Judge Smith determined, is in writing, it satisfies the statute of frauds, it became the new agreement. And I think whether a waiver argument or a modification argument, whatever it might be at the time or throughout the litigation, including the trial, he made the correct determination as to how to handle this new contract that was entered into. It was modified. And there was no reliance, and he even says in the record, I cite it in the brief, that he could ignore the agreement entirely and just go with those 2 emails. It satisfies the statute of frauds. It's a contract.
Can I ask a hypothetical, and bear with me? Let's assume, just assume, that we believe this is option contract, paragraph 1, we reject theoretically the notion that the modification is valid because of the lack of consideration. And we conclude that there was no definitive decision to sell under the strict compliance definition. And so everybody's right back where they started. Let's just assume we do that. How could the parties get out of this? In other words, let's just say that everybody now realizes we have a second chance for a do-over. What do you think, is there a way for the parties to get out of this?
I think if it was truly in the appellant's interest to control who their neighbor is, it doesn't become this financial, it became about the money eventually. That acknowledging the increase in market value of properties, that who they have as a neighbor is no longer of interest. It's trying to take back a property at a value that is exceptionally less than what the market would dictate at the moment.
And if everybody agrees that that's not fair,
Yep.
that a fair solution, this is not rocket science, is I want to get out of here, we're not getting along, you can buy the property back at fair market value. It's that simple.
Yeah.
Can the parties have a do-over? Can they undo that contract and create a new contract?
We can walk out of here today, Your Honor, and if they want to sit down and have that negotiation, that's fine. In addressing Justice Henry, though, she's not losing money every single day. The agreement is between those who sign that document. It can be part of her estate plan. So her estate plan, or however she wants to handle it going into the future, if it's valued, the fair market value is 3.5 now, whatever it might be, it's part, she has children, whatever, it's part of her estate plan. So I understand what Justice Henry was suggesting, but yes, to get out from under this, I'm not going to concede to the court that it would be in my client's interest that she should get out of this sooner rather than later.
Right.
Oh,
I
so
don't
you're
agree with
saying,
that.
you're saying she holds on, I don't know how old she is, but so she holds on for years until she dies, and so there's a new owner, and this side agreement's not binding on the new owner.
Absolutely. Yeah, it goes to her estate.
Right.
Yeah. And there's nothing that stops that.
Which creates even more reason to, if the parties are given the opportunity, to renegotiate.
If we're always open, not part of the appeal.
Well, you're here now, and we're going to take the case under advisement and get you a decision.
Thank you. Thank you, Your Honors.
One side's not going to be happy with our decision. One side will be, and so if any discussions are going to happen, they should happen extremely quickly, like within 2 weeks. And if there's any movement on that discussion, we would expect to hear from you by that point in time.
Thank you, Your Honors.
Okay, thank you both. All right, court will take a recess.
Hold on, guys, please. This court is now in session. Please be seated.
All right, still morning, so good morning. And if you just bear with me for one moment, I need to call your case number. Okay, 2024-1008. This case is partially impounded, so of course we won't use any names in the matter of RB.
Thank you, Your Honor. May it please the court, Eric Beal on behalf of the appellant RB. RB asked that the court vacate the order of commitment under Section 35 for three separate and independent reasons. First, under a matter of JP, the SJC held that a determination that an individual has a substance use disorder requires clinical testimony and a clinical diagnosis that the person has such a disorder. That decision came out just a few months after the order in this case, and so I'm requesting that the court apply retroactively the holding in matter of JP to this matter, even though the lower court judge did not have benefit of the SJC's holding, because it was decided as a matter of substantive due process. It's a constitutional right that RB should have the benefit of because he had a live matter pending appeal.
Okay.
So if we had an opponent, they might argue that there was no objection below, that the court clinician did not testify that RB had a substance use disorder. Was it argued below? That the clinician didn't give the testimony?
Your Honor, the burden is on the petitioners to prove by clear and convincing evidence that RB had a substance use disorder within the meaning of Chapter 125. So no objection would be necessary. It's the petitioner's burden to prove it. If they don't produce such evidence, then they have failed to prove that element, and the order would be denied.
As a practical matter, are these hearings, it's not a great analogy, but, in the personal protection order realm, there's an affidavit, and the, judge kind of takes things from there because court time's limited. So here, and I don't know if that happens here, but Record Appendix 14, the clinician puts in writing that she believes that RB lives with a substance use disorder. Is that sufficient, that it's in that report?
No, Your Honor. The report was not in evidence. It was not part of the evidence in this case. And as I understand, as a matter of practice, reports aren't routinely filed. A report is not required under Section 35. And some provisions of Chapter 123 do require written reports. For example, Sections 15 and 18 require written reports. The SDP statute specifically makes admissible certain reports. There's no provision like that here in Section 35. The court rules for Section 35 matters also don't require a report. And perhaps more fundamentally, I didn't realize this until preparing to be in front of the court today. The report on the docket sheet at Appendix 4, the report was actually filed after the entry of the order for civil commitment. And the court never made the report part of its findings. It would have been hearsay. It was never entered. It wasn't discussed in the trial. And for all those reasons, Your Honor, the report wasn't part of the evidence in the underlying commitment matter.
So you're saying on Record Appendix 4 that on March 14th, the order issues, and then also on March 14th, her report is filed?
Correct. The order was paper number 3, Your Honor, and the report was filed as paper number 4 after the order. Moreover, the report, I believe on page 14 of the appendix, states that the outcome is commitment. So the report, based on the text of the report and the docket entry, I think it's plain that it was filed after the order already entered. And moreover, it wasn't,
That could have
again...
been an administrative issue, though. I mean, it wasn't like it was completed and filed, weeks later. I mean, and this clinician was present in the courtroom and testified.
Yes, Your Honor. And my point is that the report is not made admissible by statute. It was never admitted or discussed.
Well, I see that. I'm reading the transcript of the hearing. I don't recall the clinician, I don't recall now off the top of my head if she referred to the report at that time. But she might have.
So what language are you referring to on page 14 that says the result is commitment? Because at the end, it says, if the court is in agreement, it says she recommends commitment, and then it says, if the court is in agreement. So where's the language you're relying on?
In part, Your Honor, I'm relying on language that is on page 14 of the appendix. It's I would say it's the paragraph above the signature in which the report says outcome RAP, which was the facility that the respondent was in fact committed to. And I would submit that if the judge did have this report, reliance on it without notice and opportunity to be heard, that this report was going to become evidence in the hearing would deprive RB of due process. But again, unlike some statutes where there's legislative intent that the written reports be submitted and that they be admissible. You could also look at Section 24 of Chapter 119 and court investigator reports. So the legislature knows how to say we want a report filed to the trial judge. It wasn't done here. And again, the report wasn't entered in evidence. And as far as I can tell from the record, it was filed after the order already entered.
Again, that could have been administrative. Is there anything in the report different from the testimony?
There are substantial differences in the report from the testimony. I'm not sure why those discrepancies exist, but RB is entitled to rely on the evidence that was adduced at the trial on his matter and submit that the evidence was insufficient, specifically both as to substance use disorder, because he wasn't diagnosed. The evidence at trial was absent that he had been diagnosed with a substance use disorder. Moreover, and the evidence jumping ahead a little bit with respect to harm, there's also the petitioners bear the burden of proving clear and convincing evidence that there's an imminent serious physical harm as a result of, in the language of Section 35, a substance use disorder. If we put aside for a moment the insufficiency of the evidence as to a disorder, in matter of minor, the SJC held that there must be a nexus, that language by a result of in Section 35 requires that there be a evidentiary nexus between the alleged harm and the substance use disorder. So here there was, accrediting the testimony of the social worker, there was a statement of self-harm made by RB, a threat of self-harm. There was also testimony that he had been using substances, but there was no testimony to tie together the statement of threatening self-harm and the substance use disorder, assuming again that there is a substance use disorder. And for that reason, I submit that there is insufficient evidence on likelihood of harm under prong 1, which is the first definition of Chapter 123, Section 1.
So you're saying the court cannot infer that the cycling in and out of rehab programs with continued substance use constitutes substance use disorder?
No, Your Honor, not under matter of JP. JP, the issue was whether or not a clinical diagnosis was required as a matter of substantive due process. And because that is lacking here, although it was present in the report, it was lacking in the evidence produced at trial. So no, a history of prior treatment wouldn't be sufficient to show at the time of trial, a current substance use disorder.
Even with active drug use, as evidenced by the hearsay of the parents and the pictures of the drugs?
I don't think there was a dispute, Your Honor, that RB had been using. He admitted to using certain substances, and there was certainly evidence of that also from hearsay statements of his parents. What we don't know about that is how much, how often, and if we're going back to the substance abuse disorder, The statutory definition also requires that it harm the person, socially or harm their health. And I didn't argue that in my brief because I was relying on the absence of a clinical diagnosis. But to answer the fuller answer to Your Honor would be, no, there would be more involved in proving the existence of a substance use disorder than merely drug use. Not everyone who uses substances, as this court held in matter of AM, has a substance use disorder.
Oh, I recognize that, but it seemed like he had an admitted problem with alcohol, and then he was himself intentionally checking himself into facilities to stop his substance use and then not completing the program more than once and using, which I'm a big fan of common sense, tells me he has a substance use disorder, or just that we're really being obtuse.
Clear, when most of the times the petitioners in these matters are the parents, and their concern is manifest for their family member. But JP made very clear to the court that the diagnosis of a substance use disorder is a clinical matter, and using the Diagnostic and Statistical Manual, the DSM. That evidence is absent here, and for that reason alone, I would urge the court to vacate the order.
I'm looking at the report, I'm looking at the conclusion of the report at the record appendix on page 14. And this is the report that you're saying was not admitted at trial, at the hearing, correct?
It was not evidence
Okay.
at the trial, no, Your Honor.
So there's when the clinician here notes 5 risk factors to meet the commitment criteria, there was testimony with respect to in my review of all 5 of these. So what more would the report have added with respect to that? In other words, there was evidence, she testified to the fact that there was cocaine use, substantial recent use, and loss of social and economic functioning. She talked about the 2 overdoses. She talked about the suicidal statements. She talked about the fact that left 2 recent treatment centers and the self-injury. Is there something I'm missing here that was not testified to during the course of the hearing, or the trial, rather?
Your Honor, the social worker did testify to use of cocaine and fentanyl. There was no testimony that there were overdoses, that there were 2 overdoses in the previous 6 months.
Okay, so that was only within this report?
That was only within the report.
Okay.
The suicidal statements, there was 1 incident with the father on March 9. There's no evidence in the transcript that it was related to substance use, but apparently the RB and the father got into a physical tussle, and RB, according to this evidence, threatened to use a BB gun to cause the police to shoot him.
Yeah.
So that was the suicidal.
And that was reported to 2 other people, to the state trooper as well as to the mother.
The trooper had no independent knowledge of it. He said that
Correct.
he had been told about that statement. The left community prematurely, he did, so there was evidence in the transcript that RB had left a treatment.
And didn't the social worker testify to the cutting incidents at the trial?
No, Your
That was
Honor.
only in the report.
That was only in the report,
Right.
Your Honor.
So thank you for clarifying that for me.
Can I follow up on that, though? I was confused by this section on risk factors to meet commitment criteria because it doesn't track, as far as I can tell, with the Chapter 123, Section 35, 3 requirements for substance use disorder, the definition of substance use disorder, which you cite in your brief. In other words, use substantially injures the person's health or substantially interferes with the person's social or economic functioning, or the person has lost the power of self-control over the use of such controlled substances. And I don't see those satisfied by these, even if they were testified to. So.
I think Your Honor is correct. I think there's a lack of evidence as to how the evidence would meet that legal definition.
Right, okay.
I didn't reach that in my brief because of what I would submit is, the total absence of any clinical testimony that RB, in fact, had a diagnosable substance use disorder.
Right. Okay.
And I see my time's almost up. If the court has no further questions.
I'll check with the panel. And I don't see any. Thank you for answering all of our questions. We appreciate it.
Thank you very much.
All right, now we'll move to the last case on our list today, which is 2024-0927, Beth Fortis versus Eugene Fortis.
Good morning. For the record, my name is Attorney Jack P. Milgram, and I represent the appellant Eugene B. Fortis. We have before the court this morning my client's appeal of a judgment that entered against him in the Probate and Family Court for Suffolk County. The issue before the panel today is whether or not the Probate and Family Court judge abused his discretion in using the date of divorce and dividing the marital assets and in not awarding my client, Mr. Fortis, greater than 50% of the net sale proceeds from the sale of the former marital home. In the case at bar, the complaint for divorce was filed February 25th, 2016, and the judgment of divorce in ISI was entered on March 20th, 2024. So, as the court can see, this was a very lengthy case. Went on for approximately 8 years.
An unfortunate situation, as the judge commented upon at the trial.
And it's the position of my client that subsequent to April 6, 2017, that the appellee made no contribution towards the marital enterprise while the case was pending. In this case, Mrs. Fortis has a son, Jalen Fortis. Jalen Fortis was adopted by my client while they were married prior to the complaint for divorce being filed. Jalen Fortis' date of birth was April 6, 1999. Therefore, he became an adult on April 6, 2017. Of course, the cases talk about, we've cited them in our brief, that one way a party to a divorce proceeding can contribute is if they're raising a minor child. But as we can see, this child became emancipated, became an adult on April 6, 2017.
I see that that's the date that you focus on in your appeal.
Correct.
But at trial, did you focus on that date, or did you focus on the date that the marital home was sold in September 2021, or even the date that there was a stipulation signed to sell the home, which would have been a couple years earlier in May of 2018?
Well,
did you argue below that the actual date should have been April 6, 2017?
We argued several dates that should be used. We talked about...
That's what two of them I've just noted, but did you also argue, of those several, did you also include April 6, 2017?
I may not have used April 6, 2017. We definitely we talked about 2018, which is when the stipulation was signed. We talked about 2021, which is when the house was sold.
So as you stand here today, which is the date that you think that should have been used by the judge?
I think that the date today that should have been used by the judge would be April 6, 2017, because if we take a look at the transcript, which we have, the court had evidence indicating that this child became 18 on that date.
I think there's no dispute that the child was emancipated on that date. That's okay.
That's
But and of course the panel will double check the record carefully, but will we find in the record at trial, in the post-submissions, at any place that that's the date that you're focused on before the appeal?
Court may not.
And what does that mean then?
Well, I don't think that it affects the outcome that, obviously, anything prior to trial or subsequent to trial is not evidence. I'm just an advocate advocating for my client. But it doesn't change the fact that during the trial, what was the evidence that came in? One, the child. Okay, enough of talking about the child. But it's more than just the child. Separate from that, it was very clear that during the time that this proceeding was pending, there wasn't any financial contribution that was made by Mrs. Forts. Back in 2016, the parties entered into a stipulation that made clear that my client was going to pay for everything, which he did all these years. He paid for the first mortgage, he paid for the second mortgage, he paid for the real estate tax.
Doesn't seem to be much dispute about that, but if we were to agree with you,
Yes.
if we were to agree that the judge erred with respect to using the date of the judgment of divorce to evaluate the pension, for example, if we were to agree, should we select one of these dates, or do we send it back and have you argue as to which one of these three dates that we now have here is the one that controls? Because it certainly makes a difference. We're talking between 2017 and 2021.
That's correct. I think that under the circumstances, I understand the question, the proper thing to do would be to send it back.
Okay.
Would be to send it back and
We seem to have a lot of cases today that are being prolonged by litigation. It's been one of those. It's been one of those mornings. Sending it back is not music to a panel's ears, I will say. But I understand your position. Okay.
Can I ask the best case that you have? Is it the best case you have that that picking an earlier date has any material consequence? Because I don't want to try and even capture the basis for domestic relations law.
Can we have a moment, please?
It might be on page 18 of your brief. That's my best guess.
That is correct.
Right, okay.
We in page 18 of the brief, we cite the Wheeler case.
Yeah.
And the Savides case.
Yeah.
And then there's a more recent case that we cited, a 2023 case. In one of the cases, the case like this pended for years, and there was a business that was owned by one party, and the value of the business exceeded over time. And the appeals court said that in that situation, it was appropriate to use an earlier date because there wasn't any contribution, either financially or otherwise, during the period of time that this business was increasing in value. And we're looking at the pension the same way. And that goes to the other part of the argument, which was the delay. In May of 2018, the parties entered into a stipulation in regards to the former marital home that was supposed to be sold within 30 days. 30 days went by, and Mrs. Forts did not cooperate in regards to signing a listing agreement. And it's not like this is a situation where my client sat on his rights.
Right.
Could
I interrupt you, though? My recollection is that the judge found that it was not simply her fault. It was both sides contributed to the delay. So are you saying that the judge made a clearly erroneous finding of fact on that point?
Well, I'm going to say several things in order to hopefully properly answer the question. The judge did write that he found that both parties caused delays. Yes, I believe that that's clearly erroneous, but in regards to the period of time in question pertaining to the sale of the marital home, 2018 to 2021, obviously you have the transcript. If you were to go back and review the transcript, I would suggest to this panel, there wasn't any evidence, I would suggest throughout the entire time period, there really isn't any evidence of delay by my client. But during the time that we're focused on the marital home, 2018 to 2021, there wasn't any evidence at trial, direct examination, cross-examination, that there was any delay caused by my client. My client was out of the house. He was paying for everything. He also had moved on to someplace else. He was paying for that. He didn't want to, obviously, to continue to support his wife and pay for another place. He wanted, no one was going to buy each other out. We knew it was going to have to be sold.
Okay, so we'll go back and check that.
And it's just, I want to be clear, it's not like my client sat on his rights.
Right.
In June, after the 30 days went by, we filed a complaint for contempt and said she didn't cooperate. Unfortunately, the court, all these years, maybe COVID came, never really addressed a complaint for contempt, but we went and filed immediately and talked about that. And the 3 years went by, and we know from the transcript from the trial that Mrs. Forts didn't disagree that she caused the delay. And she offered different justifications and excuses. She said, well, I didn't want to move until Jalen finished schooling. She said, I couldn't find suitable, adequate housing for her needs. And most importantly, she testified during the trial that she was enjoying what she was getting and what she got for basically 8 years, which was free living. Because my client, during that entire period of time, as I've indicated to this panel, was paying for everything in that condo. And to me, it seems inequitable and unjust that period of time, 2018 to 2021, while my client's pension was increasing in value, that she should be partaking in that, because
Well, so her response back is the house was increasing in value to the tune of like $150,000, and your client benefited from that. What do you say to that?
my client benefited from that, but it's 3 years. It's 3 years. Naturally, the value of real estate is going to increase, but I don't think that excuses the conduct here. I mean, this case, I understand that there was some COVID, so there were some COVID delays, but this case never should have went on for 8 years. As also indicated in the brief, this is a lady that walked out of 2 hearings. She cursed at the judge at 1 hearing. I mean, when she finally moved in 2021, why did she move in 2021? Because she decided that she finally decided that she wanted to move.
Can I ask a different question?
Sure.
The concept of alimony and seems to have a large equitable component to it. And there's also this concept of maintaining the lifestyle at the time of the marriage, and that the wife could not maintain that lifestyle without support from the husband, but the husband could. And so it seems that the judge has some equitable power here to use the resources that exist to, which in this case is largely the home and the pension, to equalize. And so was the judge abusing his or her discretion to assign 50% value here, even if we accept everything you're saying?
I would argue that's not what the judge did, because there's an alimony order in this case. Prior to this case going to judgment, within the last year, I don't have the exact date in front of me, I apologize. The court issued a temporary order for alimony of $350, and then at the time of the judgment, there was an order of $398. So I would argue that in order to comply with the theory of alimony and the lifestyle that occurred before, she got $398 a week, and the judge wasn't trying to do that in the way he divided the assets,
okay,
or the value that he used.
You're saying, I just want to make sure I understand what you're saying. I think I understand that you're saying that the alimony payments assured the marital lifestyle.
Correct.
And then the asset of the division of the house equity is a separate thing.
That is correct.
It doesn't need to be used to ensure the wife's
That is
maintains
correct.
the marital lifestyle.
That is correct.
Okay, that's your argument.
And as the panel knows, we did the order for alimony, either the temporary order or what's in the judgment. That's not part of the appeal.
Okay, thank you.
Okay. All set.
So, in conclusion, keeping in mind the age of majority of the child, keeping in mind of the lack of financial contribution by Mrs. Forts during the 8 years that this case was pending, and keeping in mind our position in regards to a lack of cooperation by Mrs. Forts during the 3 years that she delayed the sale of the former marital home, her conduct in walking out of 2 hearings, cursing at a judge at 1 hearing, We feel that it was an abuse of discretion by the judge to use the date of divorce in dividing the assets. And obviously, it's up to this court to decide if it's going to reverse, whether to impose a date or send back. But I think under the circumstances, from our point of view, it's clear it should not have been the date of divorce. If the panel doesn't have any other questions, I thank everybody's time this morning.
Panel has no further questions, so thank you
you.
very much for your time.
Thank you very much.
Just made to afternoon. Good afternoon.
I was just going to check. Good afternoon. My name is Rick Reed. May it please the court. I represent the appellee, Beth Forts, who is requesting that this court please uphold and affirm the judgment of divorce issued by the trial court and also issue an award of attorney's fees that she has incurred in this appeal. Judge Casey went through very detailed factual findings in support of his decision of how the divorce assets were divided. Now, counsel and Mr. Forts disagrees with the decision and the discretion of the trial court. That is not enough to overcome this considerable discretion that the trial judge has when making divisions of marital assets. He argues regarding
When he argues, or what the judge found that both parties were responsible for delay, I mean, 8 years is pretty long though, should the judge have sort of split it and said, well, the pension should be divided not on the date of divorce, but halfway through the divorce proceeding?
The default is the date of divorce. That is the assumed valuation for all assets. He has to find some specific justification to use a different date. In this case, no such justification existed. If you look at the docket summary that is provided in the appendix, there are only a handful of continuances, most of which were requested by the parties jointly. The other continuances were mostly related to COVID and scheduling by the court, over which my client did not have any control. As far as what she did have control over, as far as the sale of the house is concerned, that's another significant objection that they have. There was a stipulation reached between the parties having to do with that issue, and the stipulation itself provided the assumption that the parties could potentially disagree. And the terms of the stipulation provided the parties with the recourse of going back to court if they could not work out an agreement or an arrangement on the sale of the house. My client disagreed with the sale price of the house, and she, in the end, was vindicated by the increased value of the house for which the house was sold, netting the parties an additional $150,000 upon the sale of the house. So even if there was a delay in the sale of the house, the husband cannot establish that he was harmed in any way, and in fact, he was enriched due to the delay. As far as the valuation of the pension date, just circling back, forgive me, I've lost my train of thought.
Pension.
The pension, yes. The cases cited, the Wheeler case and Savides case, are factually distinguishable from this one. The pension was something that was born of the marriage. Ms. Forts contributed as best she could during the marriage. Up until 2013, she worked as an EMT. She also worked as a dental assistant. And in 2013, she was no longer able to work. She was no longer able to earn an income. She focused on child-rearing duties and responsibilities. Judge Casey specifically found that she was unable to work because of her considerable disabilities, including pulmonary disease, arthritis, and depression. The suggestion that she did not contribute to the marriage assumes that she was able to work, assumes that she was able to earn an income equal to or equivalent of what Mr. Forts was able to contribute. There was no finding of that. There was a specific finding against that. There was a specific findings that $398 a week in alimony was insufficient to meet her needs, which indicates to me that Judge Casey was significantly relying upon the division of the marital estate. And if you look at the factual findings bit by bit, it is clear that Ms. Forts did not have the ability to support herself without the division of the marital estate as it was done. In fact, it would lead me to suggest that perhaps maybe she should have had a more favorable division in her favor. But Ms. Forts was not willing to appeal that. She does not have the resources to appeal it. She does not have the funds to support an appeal, which is why I'm requesting attorney's fees. husband was unable to cite any specific facts that were clearly erroneous. They were unable to establish any indication that Judge Casey abused his discretion in the division of the marital estate. This is simply a disagreement with a trial judge. That is insufficient grounds to bring an appeal. Ms. Forts has incurred additional attorney's fees beyond the trial and to oppose this appeal in support of the judgment of divorce that she does not have. So we are requesting reasonable attorney's fees that she has incurred as a virtue of this appeal. I would also refer back to the fact that Judge Casey was very careful in making sure, and actually Judge Ward as well, that once the house was sold, up until that point, husband was responsible for most of the costs related to the house. Not all of them. Ms. Forts did provide some payment. I think it was electricity and some cable bills. But other than that, Mr. Forts was primarily responsible for all of those expenses. However, up until that point, he was not paying alimony. Once the house sold, then Judge Ward said in her order of that date, now that the house was sold, the issue of support needs to be addressed. And it was that date, I believe it was in September of 2021, when the house sold, that is the bright line at which alimony, the obligation for alimony began. So to suggest, I believe there was a suggestion that he was paying alimony at the same time he was supporting Ms. Forts with the house. That is not the case, and that would have been inequitable, but that is not what happened. Judge Casey was very specific in making sure that any credits for alimony was attributed only after the house was sold. Any further questions?
The panel has no further questions. If there's anything else you'd want to tell us, of course, you still have some time, but it's none of your arguments that are in your brief that you may not have mentioned are going to be waived, so we will consider all of them. So
I have nothing further, Your Honor. I will rely on the brief and the supporting documents.
all right.
Thank you very much.
Both have a good afternoon. We'll take the case under advisement, and thank you very much.
Thank you.
All right, the court will stand in recess. Thank you.
Court all rise, please.